Now, I'd like to discuss the case of In re Perelman, cited at 123 AD 3rd 436 of the First Department in 2014. And as the disclaimer, Eileen Cooper and I were involved in that case because it is a seminal case involving the statute of limitations and pleading requirements. In matter of Perelman, Ron Perelman, the executor of the estate of Claudia Cohen, brought a proceeding for the discovery and turnover of assets. The crux of the claim was that the decedent may have owned some stock in Hudson News Corp., which was owned by the Cohen family, or may have owned some stock in another Cohen family business at some point in time during her life. Through that claim, the fiduciary wanted to open up decades of corporate books and records that he otherwise would not have been entitled to see, claiming that he needed to see those books and records to find out if perhaps the decedent owned some stock. Now, the documentary evidence in that case showed that the decedent had owned some stock in Hudson News Corp. In 1985, but sold it in 1990 pursuant to a shareholders agreement. And under the terms of that shareholders agreement, the decedent received installment payments for her interest over the course of 5 years. The fiduciary argued that he needed to ascertain whether the decedent had been paid everything that she was owed under that shareholders agreement. Now, there was a motion to dismiss, and the surrogates court denied it, finding that there were some unanswered questions as to the total number of shares the decedent acquired when she acquired her interest in 1985 and how the 1990 sale transaction was completed. But the appellate division reversed. It found that the claim was barred by the statute of limitations. It first found that any claim to recover the Hudson News stock accrued at the time of the conversion, which was the date of the 1990 sale. And it was subject to a 3-year statute of limitations that expired long before the decedent's death, which occurred in 2007. It then found that even a breach of contract claim, which the fiduciary had alleged, was time barred because that claim, governed by a 6-year statute of limitations, accrued on the date of the last installment payment and expired 6 years thereafter. In our case, that expiration date was 2001, again, long before the decedent's death. The court also found that the fiduciary offered nothing more than speculation that the decedent may not have been paid everything she was owed under the 1990 sale transaction agreement. Now, that statement is important because it does show that the courts give greater latitude to the pleadings of a discovery petition, which merely seeks information and which can be based upon information and belief, than to the pleadings of a turnover proceeding, which must be specific and cannot be purely speculative. The courts will generally not dismiss a proceeding at the inquisitorial phase. In re Perelman, the petition there was a hybrid. It sought both discovery and the turnover of assets. Therefore, something more than pure speculation was needed to survive the motion to dismiss.